All right, welcome everyone to today's webinar on what nonprofit organizations need to know about New York employment laws to avoid costly legal mistakes. I'm joined by Lisa Brauner with Perlman and Perlman. Just a couple housekeeping items. Be sure to use the questions pane in the GoToWebinar control panel to write your questions, and we will address those questions at the end of the webinar. And additionally, we will be recording today's webinar, so we will be sending that recording out to all registrants as soon as we have it uploaded. And with that, Lisa, feel free to take it away.
Thank you very much, Sam. Good afternoon, everyone. I'm Lisa Brauner. I'm head of Perlman and Perlman's employment law practice, and we're going to be covering a lot of ground today in an hour. We can't possibly cover all of the employment law developments in New York that are affecting nonprofits, but I am going to touch on a bunch of them. Some of them earlier this year, and some quite recently as this month. So this is not legal advice. I'm not providing legal advice. It's general information for you to know about, to be aware of. And I'm sure the information will be available later with JMT if there's anything that you wanted to refer back to. So as I mentioned, I'm head of Perlman and Perlman's employment law practice, and I work with nonprofits on helping them stay compliant with employment laws. So we're going to talk about the legal developments in New York this year and some best practices in connection with those things so that you can avoid costly legal mistakes. We have seen in the news, in the headlines, a lot this year about sexual harassment in particular. And nonprofit organizations are not immune from charges of sexual harassment, as we know. There have been many high-profile cases reported in the news of CEOs at nonprofit organizations who've had sexual harassment charges leveled against them. And so in response to really what's been a tidal wave of claims and people coming forward who are victims of sexual harassment, New York State has responded, both New York State and New York City. And in April of this year, Governor Cuomo had signed some measures in the 2018-2019 budget bill requiring all employers in New York State, regardless of size, to adopt sexual harassment prevention policies and training and some other measures that went into effect. One of the changes that was implemented was an amendment to New York State human rights law, which now expands protections beyond employees and job applicants to even certain non-employees. So expands the law to protect independent contractors, vendors, consultants who are engaged to perform services in the workplace. So think of contractors you may have on site and independent contractors on site performing work. They are now protected from sexual harassment. So what does that mean? We're going to talk about that. Well, what does that mean in terms of what you should do, even though you're not employing this person, to ensure that they're aware of the organization's policy prohibiting sexual harassment, that they know what the complaint procedure is, and who they should report to. So some of the other things that came about as a result of the measures that Governor Cuomo put in place were effective July of this year. Non-disclosure provisions are prohibited in agreements settling claims of sexual harassment, unless the person complaining of the sexual harassment wants to include a confidentiality provision in that agreement. And specifically, that person will have 21 days to consider whether to include that non-disclosure provision, and then 7 days to change their mind. So confidentiality provisions, as you probably know, have been pretty standard to have in any type of settlement of any type of employment discrimination claim. So this is something quite new, and there's a period of time for the individual to consider whether or not they want to have a non-disclosure provision at all. So this is something new, so you want to make sure that any agreements going forward that you may enter into have this carve out. Also put in place July 11th of this year are restrictions on the use of mandatory arbitration provisions. So if you currently have an mandatory arbitration provision for resolution of all employment disputes, well, now there's a carve out, cannot be used for sexual harassment claims. There's some exception where there are collective bargaining agreements. However, the general rule is that those are, unless allowed by federal law, those types of mandatory arbitration provisions are prohibited with respect to sexual harassment. So what else happened under these changes in New York State? Well, as you probably know and hopefully have implemented, New York State has required by October 9th of this year that all employers have adopted a sex harassment prevention policy and distributed to their employees that meets or exceeds the standards that are required by New York State. New York State recently issued a model sex harassment prevention policy, model training, and employers can create their own sex harassment policies. They don't need to use the model policy, but their policies must meet or exceed the standards in the model policy. And employers need to provide copies of those policies to employees and should be getting signed acknowledgments of receipt that those employees have received those policies. There's also a mandatory annual training on sex harassment prevention that New York State requires of all employers, even if you have a single employee, that needs to be completed by October 9th of 2019. So the state's given some extra time for that.
Yeah.
In addition, for those of your organizations that have contracts with New York State, you as a state contractor will be required to, by January 1st of 2019, submit an affirmation that your organization has a sex harassment prevention policy that meets the minimum standards of the state, and that you've trained your employees. Presumably, the deadline has also been extended with respect to training, but the state has not yet clarified whether or not that's the case. But this rule about January 1st, this provision, was put into effect before the state decided to extend the training deadline to October 9th, 2019. And I have a link here to find out more information, a link to New York State. So as I mentioned, New York State issued model policy training and also a poster that you may want to post in your workplace that provides information on where employees can find who they can contact if they have a complaint of sexual harassment. So we're going to talk a little bit more about what what needs to be in your policy, what New York State requires, and you have to have, there are some very specific things that need to be in that policy. That sex harassment prevention policy needs to explicitly state that your organization prohibits sexual harassment, and that it does so consistent with the definitions and information provided by New York State. Provide examples of prohibited sexual harassment, the types of conduct that would constitute sexual harassment, the kind of conduct that's prohibited by your organization. The policy has to provide information on the various federal, state, and local laws that prohibit sexual harassment and address the remedies that are available to victims of sexual harassment, and also have a standard complaint form. So I know for many employers and for many clients who may have had, who had sex harassment prevention policies in place already,
Yeah.
that they may not have had a complaint form, a standard complaint form attached or with the policy, or maybe even a specific form itself. But now the policy must contain a standard complaint form. I've seen some clients who will provide a link where they have an intranet where employees can access that complaint form on the intranet. But the policy must have a standard complaint form. It has to describe what your procedure is for conducting an investigation of a claim of sexual harassment, how those investigations are handled, that your process ensures due process for all parties. The policy has to inform employees of their rights of redress, as I mentioned, what their remedies are, what are the different forums that they can go to adjudicate their claims with different agencies like the EOC and New York State Division of Human Rights, New York City Commission on Human Rights, and also judicially where they can go. Your policy has to state that sex harassment is a type of employee misconduct, that it's going to be that it's prohibited, that it's going to be sanctioned if somebody engages in it, or your supervisors fail to prevent the behavior from occurring, that they knowingly allow the behavior to continue, that there'll be sanctions, disciplinary action taken for those things. And importantly, the policy must address the prohibition on retaliation, very important component of these policies, that employees understand that retaliation is against the law and that there will be consequences for anyone who retaliates against an employee. The training must be done annually. It needs to be an interactive training. As I mentioned, there need to be examples of unlawful sexual harassment, and it also has to include information that addresses conduct by supervisors and additional responsibilities for supervisors as well. So that's New York State. And New York State has a website that has all the information regarding the kinds of things that the policy and training need to contain. So around kind of at the same time, or on parallel tracks, New York City was also busy enacting its own legislation, and on May 9th, Mayor de Blasio signed a series of bills called the Stop Sexual Harassment in New York City Act. So again, this applies to employers of all sizes, even though New York State human rights law generally applies to employers of 4 or more employees. The prohibition on sexual harassment applies to employers of all sizes. New York City set a deadline of September 6th for all New York City employers to post sex harassment prevention posters regarding rights and responsibilities. And those notices should be posted in English, and if you have a workforce whose primary language is something other than English, you post it in English and that other language. The New York City Commission on Human Rights should be issuing posters in other languages. They have issued it in Spanish already, and it needs to be posted conspicuously in employee break rooms and places where you have your other mandatory labor postings. And in addition to that posted notice, New York City employers are required to provide all employees upon hire with a fact sheet about sexual harassment and employee rights. A fact sheet and information sheet that New York City Commission on Human Rights has prepared. And New York City also has a training requirement. So all New York City employers that have 15 or more employees, so they have a certain threshold size for employers, must conduct an interactive sex harassment prevention training by April 1st, 2019. So in some ways it's more limited because it goes to employers of a certain size, but New York State already requires training for all employers regardless of size. So New York City's training requirements are similar but not identical to New York State. It needs to be interactive and it needs to be on an annual basis, just as with New York State training throughout New York State. But it must also address, what sexual harassment is and what is not, providing examples in the training. The processes, complaint processes, internal and external, and the importance of bystander intervention. There also needs to be additional training for supervisors and managers to address their specific responsibilities, legal responsibilities as a supervisor, and measures that they can use to address sexual harassment complaints. New York City employers are required to keep a record of all of their trainings and an employee acknowledgement of the training for 3 years. And another change that occurred is now the statute of limitations was expanded for individuals to bring claims of sexual harassment to the New York City Commission on Human Rights. I should say gender-based harassment, more broadly gender-based harassment. The statute of limitations has been extended to 3 years for someone to file a claim with New York City Commission on Human Rights. Now, shifting away now from the topic of gender-based harassment, but other types of protections that have been implemented this year. New York was a very busy year for different types of legislation affecting employees in New York City. So back in May, you may recall that New York City's Paid Sick Leave Act was expanded to include time off for safe leave, which we'll talk about a little bit more. July 18th of this year, New York City enacted, or New York City's temporary schedule change law took effect. And October 16th, New York City's cooperative dialogue requirement for providing reasonable accommodations took effect. So very recently, that was one of the most recent developments that's happened so far. So we'll talk about the Earned Safe Time Act, Safe and Sick Time Act. And what that is it's safe leave is when an employee or an employee's family member has been the victim of a family offense matter, a sexual offense, stalking, or human trafficking. That employee, assuming they've met the eligibility threshold, which is the exact same as it is for paid sick leave, which is the person has worked 80 hours in a calendar year, and they can begin to take that. Paid safe leave after they have worked for 120 days for that particular employer. So what is safe leave for? It's to be able to get services from a domestic violence shelter, rape crisis center, other shelters or services programs, to participate in safety planning, to relocate, to take actions to protect the employee's safety, to meet with an attorney or social services provider or counselor of some sort in connection with the fact that they or their family member has been a victim of one of these types of offenses, to get advice whether it's relating to custody, visitation, matrimonial issues, orders of protection, immigration, housing, discrimination, and to prepare for, participate in a criminal or civil proceeding. It's also if the person needs to file a domestic incident report with law enforcement, or they need to meet with the district attorney's office. They need, because of a domestic violence or family offense matter, they need to enroll their child in a new school or take some other action to maintain, improve, or restore their physical or psychological or economic health and safety for that employee or a family member. Another significant change that happened with the inclusion of Safe Time Act was an expansion of who is a family member for this law. So it extends beyond children, spouses, domestic partners, siblings, grandchildren, grandparents, and child or parent of a spouse or domestic partner to include any individual related by blood to the employee, And any individual whose close relationship with the employee is equivalent to that of a family relationship. So here's a couple of scenarios to see how this law plays out. Let's say with one of your employees. Your employee Ruby's been followed lately by a neighbor. Recently, someone broke into her apartment while she and her 10-year-old were out. No one was physically harmed, but she suspects it's the person who's been following her, and she doesn't feel safe staying in her neighborhood. So she's going to move with her mom to another school district, move in with her mom to another school district, and she needs to take time off from work to enroll her son in a new school and move her belongings. So may she take paid sick for this, even though this is not a domestic violence situation? Yes. She may take paid safe leave under the Safe and Sick Leave Act because she's taking time off to move and she's enrolling her son in a new school, because the acts against her are some of the acts that could constitute crime of stalking. That's one of the categories for which safe leave can be provided. Stalking and threats or acts that may constitute stalking are covered by New York City's paid safe and sick leave. And so employees may use that paid time to go to things, as I mentioned, about relocating, enrolling their children in a new school, and that type of thing. Here's another scenario. Dana needs to take a half a day off work for counseling with her pastor following a domestic incident with her ex-boyfriend. May she take safe leave for that? Yes, she may. She was the victim of a family offense matter, and she's getting counselors to help her psychological health. What about taking paid safe leave to go to court to get a restraining order against her ex-boyfriend? Yes, she's going to court to protect herself following a family offense matter. So she may use paid safe leave for this type of thing. Also important to know that this law and other laws that we're speaking about today have retaliation prohibitions. And those are an important component of any of these laws because sometimes there is retaliation against a person for exercising their rights. So this law also prohibits retaliation for an individual taking safe leave or exercising their right to do it, to take that leave. It also requires that employers issue a notice of employee rights under the Safe and Sick Leave Act, and those can be found at New York City Department of Consumer Affairs website, both in English and in Spanish, and maybe in other languages as well. If you have Spanish-speaking employees, you'll want to provide that notice in Spanish as well as in English. So the consequences for violation, there are various monetary penalties that they vary depending on what the nature of the violation is. If somebody took safe or sick leave, but then they weren't compensated for it, there's a penalty for that. If they requested the safe or sick leave and they were denied that request, and or they were required to work additional hours without their consent, or make up for those hours, or find a replacement worker, all of those things are unlawful to require an employee to do. So there are different penalties for that as well. And if you have multiple employees who have been inappropriately denied safe or sick leave, the penalties can really mount up. And the Department of Consumer Affairs does investigate these and does prosecute and does go after employers that have not provided the leave, or where somebody's been retaliated against for taking the leave, or where the employers failed to properly track the leave. So compliance is key, and also educating your managers. We'll get to this at the end, and just in terms of the best practice, but training your managers on what the law requires, making sure your policies are updated to reflect these employee rights are very important, that you have policies, that you have the postings up and that managers understand what the law requires so that they are not inadvertently denying somebody a right that that person's entitled to. As I mentioned, that law prohibits, the Earned Safe and Sick Time Act prohibits retaliation, imposes penalties if an individual were unlawfully discharged as a result of either taking the leave or they were terminated after requesting the leave. And the city can also impose a civil penalty on employers for violation. And those increase with multiple violations. New York City also enacted, as I mentioned in July, a temporary schedule change law that requires employers, New York City employers, to grant a temporary change to hours, times, or locations of work to accommodate a worker's personal event. And the personal event, which we'll get to in a minute, is defined. So there are only specific reasons why that constitute a personal event that an employee is entitled to take this temporary schedule change. An employer must grant an employee's request for a temporary schedule change for either 2 occasions per calendar year, each totaling 1 business day, or 1 occasion for up to 2 business days for a personal event. So let's look at this scenario. Rose notifies her employer on July 20th. She'll need to change her schedule on July 24th. She needs to care for her daughter because this child care provider won't be available in the afternoon. Rose, who's scheduled to work on July 24th from 8 to 4, proposes working from 6 to 2 on that day instead. Is her employer required to allow Rose to change her hours as Rose has proposed under this temporary schedule change law? No, the employer is not. Although Rose's employer must grant her a temporary change to her work schedule on up to 2 occasions each calendar year, her employer does not have to grant the specific type of temporary change proposed by Rose. Instead, the employer can tell her that she can take an unpaid leave from 2 to 4 to accommodate her personal event. So the employer has to provide it or provide unpaid leave. So what is a personal event? When can this temporary schedule change be used? If it's needed to care for a minor child for whom the employee has direct and ongoing care, like the situation of a parent needing to take care of their child who's under the age of 18, need to care for a care recipient, which means a care recipient is someone with a disability who is a member of the employee's family or household and relies on that caregiver for medical care or to meet their daily living needs. Or a personal event can be a need to attend a legal proceeding or a hearing for subsistence benefits to which the employee, a family member, or the employee's care recipient is a party. Or any circumstance that would be a basis for them to use safe or sick time under New York City's Earned Safe or Sick Time Act. So if there's a reason they need to leave for that, care and treatment of the employer or family member, we talked about with safe leave, that somebody needs to get help with safety measures, with relocating because of a family offense or stalking. So assistance or safety measures if the employer or family member is the victim of an act of domestic violence or a threat of domestic violence or unwanted sexual contact, stalking, or human trafficking. A temporary schedule change is about changing your hours or the location where the person is expected to work. So it could be the employee makes a request to work from home instead of from the office. The employee wants to swap certain work hours or change part of their work schedule. They want to use unpaid leave. The employer can offer to the employee, can offer to the employee to use paid leave if that's something of interest to the employee, but is not required to offer paid time off. And in terms of the making the request and the notice requirements, an employee has to let the employer know as soon as they are aware of the need for the temporary schedule change, they need to let their employer know. And they can make the request verbally or in writing. And the request has to include the date of the shift change, and the fact that the change is due to a qualifying personal event. It has to be one of the qualifying events in order to fall under this law. And a proposal of the type of temporary change requested. Obviously, the employee would tell you, as the employer, I'd like to work from home, I'd like to work remotely, I'd like to change my hours from this to this for today. If the request is verbal, the employee then has to follow up with a written request once they get back to work by the second business day after they have returned to work. What's an employer's obligation? The employer must immediately respond to an employee's request for a temporary schedule change. Within 14 days of receiving the request in writing, the employer must provide a detailed written response to the employee that includes whether the request was granted or denied, how the request was accommodated, or a reason for the denial if it was denied, and how many requests the employee has made for temporary schedule changes and how many days the employee has left in the calendar year for temporary schedule changes, because this is the amount of time they may take within a calendar year. Now, the employer has to either approve the eligible employee's proposal or provide unpaid leave. And if you, as the employer, decide that you're going to require the employee to take unpaid leave, that is not a denial of that employee's schedule change request. You, as the employer, have the option to say, no, I'm not accepting your proposal. Instead, you need to take unpaid leave. As I said, the employer may offer the employee the ability to use paid time off, but they may not require the employee to use the leave earned under paid safe and sick for a temporary schedule change, or requiring supporting documentation, but an employer may discipline an employee if they learned that the employee had taken that schedule change for an unauthorized reason. So who's not covered by this law? Government employees, employees subject to a collective bargaining agreement where the agreement covers temporary changes, and then certain employees in motion picture, television, and live entertainment industries. Just as with the paid safe and sick leave, temporary schedule change law also prohibits retaliation against an employee for exercising their rights under this law, for requesting the schedule change, for requesting subsequent schedule changes, and that's a prohibition as well. In addition, employers need to post a poster that the Department of Consumer Affairs has created called "You Have a Right to Temporary Changes to Your Work Schedule." That poster should be posted in your workplace, conspicuously where you have your other labor postings, where your employees can see them, in English, and also in any language that's the primary language of at least 5% of your workforce. So long as that poster is being provided by the Department of Consumer Affairs, you don't need to create a poster in another language that the Department of Consumer Affairs has not provided. Oh, and I will say this just for a moment to go back to sexual harassment policies and training, that if you have a workforce, a Spanish-speaking workforce, or a workforce of a large population that speaks a language other than English, then you will want to consider having your policy and your training translated into that language. And I believe that the state intends to, or has actually created a model policy in Spanish. I don't know whether that will be or when in other languages, or whether it intends to do a model training in other languages. But certainly you want your workforce to be, to be able to understand the policy that they received and get an acknowledgement that they have read it and understood it. So going back to temporary schedule change law, there are also consequences for noncompliance. There are penalties for violations that increase with repeat violations and additional penalties for engaging in retaliation. What happens if, what else beyond penalties are there? Well, an employee can actually bring a lawsuit in court, a civil court action to seek monetary and other relief, or they can file a complaint with the Office of Labor Policy and Standards at the New York City Department of Consumer Affairs, which is the city agency that's enforcing this law. They also enforce the violations of the Earned Safe and Paid Safe and Sick Leave Act. So the cooperative dialogue in New York City. So as you know, employers have a legal obligation to reasonably accommodate disabilities. In New York City, employers also have obligations to reasonably accommodate pregnancy, childbirth, and related medical conditions. And in New York City, there's an obligation to reasonably accommodate domestic violence victims. Employers also have a legal obligation to reasonably accommodate an employee's religious practices and beliefs. And it's always been the case under federal, state, and local laws that in order to reasonably accommodate disabilities, let's say, an employer needs to engage in a good faith interactive process to determine a reasonable accommodation. When New York City goes one step further and is now requiring that employers engage in what's called a cooperative dialogue, which requires employers to provide a written determination of whether an employee's request for accommodation has been granted or denied. So when an employer learns, either directly or indirectly, that an employee needs an accommodation due to a disability, let's say, the employer has to initiate a dialogue with that person that addresses that person's needs. So it's really an individualized inquiry and considers possible accommodations without creating hardship on the employer. So in other words, it doesn't need to be the employee who makes the initial request. The employer then, as I said, must notify the individual in writing of the determination. And this cooperative dialogue amendment to New York City human rights law expands the reasonable accommodation requirement of engaging in a good faith interactive process by explicitly requiring the employer to engage in a dialogue with the employee. As I said, regardless of whether the employee initiates it, regarding that person's needs, regarding potential accommodations,
it's a really hard
any alternative accommodations,
to an office party,
and to address any difficulties the accommodations may pose for the organization.
These are the exact words that we said.
Employees are not required to disclose their disability in a cooperative dialogue or even before an offer of employment. And it is unlawful for an employer to terminate an employee for failing to disclose their disability status or need for a reasonable accommodation. The employer has to engage in a cooperative dialogue within a reasonable time with the person who's requested an accommodation or who the organization has noticed that they should have known that that person may require an accommodation related to a disability. So, for example, if an employer has knowledge an employee's performance at work is diminished or their behavior at work could lead to an adverse action and has a reasonable basis to believe the issue is related to a disability, the employer must initiate a cooperative dialogue with the employee, but should not ask the employee if they have a disability. So New York City has recently issued guidance, very lengthy guidance, to employers and others, to places of public accommodation as well, on handling requests for reasonable accommodation where some of these things have come up. So this is a very important development in terms of engaging in reasonable accommodation. Engaging in a good faith interactive process to determine a reasonable accommodation. Another thing that's interesting about this new change in the law is that each time an individual makes a new request for reasonable accommodation, the employer must engage in a cooperative dialogue with the individual. So someone may request time off for a period of time. The employer engages with them, grants them the time off, and then the employee comes back and they need additional time. Their doctor has said that they need additional time. The employer must continue to engage as a continuing obligation to engage in a good faith interactive process, to engage in a cooperative dialogue with the employee to arrive at a reasonable determination, a reasonable accommodation, so long as that it does not pose an undue hardship on the organization. So importantly is ensuring that a written determination is given to the employee as to whether or not the request is granted or denied.
Not awful.
Failing to engage in a cooperative dialogue with an individual requesting an accommodation, which includes now failing to provide that written determination, is now an independent violation of New York City human rights law.
Better than Lucy yesterday.
And those who are aggrieved, they can bring lawsuit in court, recover all remedies that are available under New York City human rights law. They could alternatively bring a proceeding before New York City Commission on Human Rights. And employers who are found liable
way higher than
for having violated this cooperative dialogue requirement may be subject to damages for back pay, for emotional distress, for attorney's fees, and or for civil penalties up to $125,000 per violation, and up to $250,000 for a willful, wanton, or malicious violation. And they may also be directed to conduct employee training and update policies with particular language. And there really has been quite a
must be nice.
A continuing surge of claims of disability discrimination.
Cool.
I believe after race discrimination, that may be the second highest category of the types of
accidentally left
claims
his desk while he had a meeting with me, and I had to pretend like I
actually the largest category, which we'll talk about in a moment, is retaliation. So switching now to just a reminder for employers in New York that you will want to update your minimum wage postings in the workplace. Minimum wage is going up December 31st of this year, as it does every year. For New York City employers, large employers with those are employers with 11 or more employees. Minimum wage is going up to $15 an hour as of December 31st, 2018. For smaller employers in New York City, 10 or fewer employees,
old director
minimum wage is going up to $13.50 an hour as of December 31st of this year. On Long Island and Westchester, it's going up to $12 an hour, and the rest of New York State going to $11.10 an hour. And those will increase. As you may know, in order for an individual to be deemed exempt from overtime pay laws, they typically need to meet both a salary threshold and a duties test. And every year, the threshold that they need to meet.
Have you actually gotten one yet?
Has been increasing. New York State has its own salary threshold that is higher than the federal salary threshold.
Like $500.
So in other words, the threshold means that anyone who falls below that threshold is automatically non-exempt from overtime pay laws, meaning they're automatically entitled to overtime pay. when they work 40 hours. They work more than 40 hours in a work week. So there's the Federal Fair Labor Standards Act, and then New York State has its own labor law. So the salary thresholds are going up this year for executive and administrative exempt employees. As you can see, for New York City, large employers of 11 employees or more, as of December 31st, 2018, the salary threshold for exempt and administrative employees is $1,125 a week. It was $975 a week. So that means for a New York City employer that has 11 or more employees, if they have employees earning below $1,125 a week, that person is automatically entitled to overtime pay after working 40 hours in a work week under New York State's labor law. And you can see in New York City, for smaller employers, that number is $1,012.50 a week. That's the threshold. For Long Island and Westchester, it is $900 a week, and for the remainder of New York State, it's $832 a week. Now, just because somebody is earning above that threshold does not mean that they are automatically exempt from overtime pay, from New York labor law's overtime pay requirements. All it means is that they've met the salary threshold requirement. They also need to meet a duties test. They need to meet the duties required for executive and or administrative exempt employees in order to be exempt from overtime pay.
Looking at about 12 minutes left, Lisa.
Okay, so we're gonna wrap up with a couple more slides and then some best practices. Just a reminder, New York paid family leave, which took effect January 1st. Sure you all have implemented already the payroll deductions for this, but this is just a reminder that at the beginning of next year, that employees will be eligible for 10 weeks of paid family leave at 55% of their the employee's average weekly wage, unless it is unless that wage is higher than the state average weekly wage. And if it is, then the benefit they receive is capped at 55% of the state average weekly wage, which I do not know if that has yet been set. It changes every year. It goes up every year. So we will stay tuned to see what number the state has indicated as the state average weekly wage for 2019. Now, just to go over some best practices, hopefully you have all implemented your your updated sex harassment prevention policies and complaint forms. You've done your mandatory postings. If you haven't, you really want to get those in place. Make sure that you have not just those policies, but that you have very strong policies prohibiting retaliation as well, and that you're training all of your managers and staff on what the law requires, what the employee's rights are, and what the supervisor's responsibilities are to prevent sexual harassment and other types of discrimination harassment in the workplace. And that managers are well trained on what retaliation looks like and how to prevent it and how to ensure that they don't engage in it. Also, first and foremost is you want to ensure accountability to the extent you're in a position to do that at your organization, because it's all about the tone from the top of the organization in terms of preventing sexual harassment. That's where it starts, and that's the message that needs to be communicated at the highest levels of the organization, including at the board. Your board should know about your sex harassment prevention policy. They should be familiar with it. They should understand the organization has a policy. They should know how complaints get handled. They should know how to handle a complaint if an employee makes the complaint to a board member. An employee may complain to a board member about the CEO of the organization, and the board should be trained on how to handle complaints of discrimination that come to them, or that come to them or brought to their attention, and how that's supposed to be addressed, what the board is supposed to do. And also the board needs to be aware of what the policies are so that they themselves are not engaging in sexual harassment. So that's very important too. You may have board members who interact with the constituents of your organization, with staff members, and they need to understand as well that the organization has no tolerance for sexual harassment regardless of who commits it, and they need to understand the policy and agree that they will abide by it as well. Also, you may want to consider creating codes of conduct for places in which your employees may be. You have an obligation to keep your employees safe, even when they are not necessarily within your physical office, but you are also responsible for them when they are at events that you've sponsored. So if you have a conference that you sponsor, you may want to make sure that you have a code of conduct that is going to be signed by, acknowledged by anyone who's attending that conference, that they understand that the organization prohibits sexual harassment, that you expect them to act professionally and abide by certain rules. So you may think about that for conferences and other things, other places that are an extension of your workplace. Ensure that your independent contractors who are now protected under New York state law from sexual harassment, make sure that they know. If you have independent contractors, vendors who are engaged to perform services at your workplace, you make sure that they have a copy of your policy, that you've thought about if they had a complaint of sexual harassment, if one of our employees sexually harassed them, who are they supposed to go to? Maybe they go to human resources, but maybe there's another complaint avenue for them. Maybe they're supposed to go to the point person that they deal with. So it's something to think about in terms of what is the policy you're going to give them and the complaint procedure, but that they should be made aware of it, and also that they are trained on your policy and complaint procedure. As I mentioned before, because it's really one of the greatest risk factors for employers and really can be extremely costly for nonprofit organizations, is the issue of retaliation. There was a case just a couple years ago, a retaliation case for millions of dollars settled by a nonprofit organization. And these types of claims can, if founded, can be very expensive for an employer. Retaliation is sometimes a bigger problem than a claim where there may not even be a claim of discrimination, may not be discrimination, but the retaliation claim may stick. And close to 50% of all charges filed with the U.S. Equal Employment Opportunity Commission, which is the federal agency that enforces some of the federal anti-discrimination laws, almost 50% of charges filed have a retaliation claim component. So it's crucial that you do training on what retaliation is, what's unlawful, and how to prevent it. Also, to ensure that you are engaging with your legal counsel so that there's attorney-client privilege, an audit of your pay practices. This is an area that is growing, the EEOC is focused on, and that is gender pay equity, women being paid less than men for doing the same work. You want to think about conducting a self-audit of your pay practices to ensure there's no discrimination based on gender or race or another legally protected category. Reasonable accommodation. You may want to consider updating your policies that you have in your handbook on reasonable accommodation, making sure that you have forms for employees to request reasonable accommodation, and templates and forms and processes in place, and that you've posted with respect to pregnancy accommodation that you've posted the New York City mandatory posters. And critically, that you have trained your managers on how to handle a request for reasonable accommodation, what a manager is supposed to do if an employee comes to them and says, I'm pregnant. My doctor says I need to do the following, or I have a medical condition. Managers need to be trained, even if your process is that human resources handles it, the manager needs to know how they are supposed to address the request. With respect to the temporary schedule change law, updating your policies to reflect that employees have that right to do that for qualifying personal events, that you've posted the necessary poster, you've trained your supervisors on the legal requirements and the prohibition against retaliation, and maintain written documentation of requests that are made for the schedule changes and your responses, so you have a record of how many requests were made that year. Same for paid safe and sick leave. That has to be tracked. You may want to update your policies to make sure that you have explained to employees what this is and that they have the right to take this. You might consider even having a policy on dealing with domestic violence. It is a legally protected category, domestic violence victims, and you may want to have a statement on with respect to domestic violence and what your policies and procedures are with respect to protecting those victims of domestic violence. There's an employee notice of employee rights. You want to make sure that that employees have been provided with a copy of that, and that you have documentation that they've received it, and training your managers. So just to wrap up on things to look for coming up, we were expecting that this month we were going to see a new federal overtime rule for those of you that are covered by the Federal Fair Labor Standards Act. We were expecting the U.S. Department of Labor, they had announced in their fall regulatory agenda that they were going to issue a new overtime rule proposal this month. So be on the lookout this month for that. You might remember that last year, a federal district court judge had invalidated an Obama-era FLSA regulation that would have required employers to pay overtime to workers who were making less than the equivalent of $47,476 a year, regardless of whether they were eligible for exemption. So we're waiting to hear on that. The National Labor Relations Board has made some substantial changes to employee handbook standards, more pro-employer, and we may see more of that. And we may expect to see some increased focus on reasonable accommodations and perhaps more sex harassment claims being filed, pregnancy discrimination, and transgender discrimination and pay equity claims. So now I'm happy to take your questions.
Yeah, if you have any questions, please use the questions panel and the GoToWebinar controls.
And if not, I'm also happy to take questions at a later time if you'd like to contact me. I can be reached at lisa@perlman.com.
Give it a minute or two. All right, it doesn't really look like we have any questions, so just have to say thank you, Lisa, so much for doing this webinar for us. And
my pleasure.
All the attendees should keep an eye out for the recording of this webinar. and also some invitations to future expert speaker webinars that we will be hosting. So
Thank
thanks a
you.
lot, Lisa.